So, Ethan, the U.S. EPA recently finalized the rule on reporting on PFAS for
Yeah.
the toxic release inventory. First of all, tell us about what that is, what that whole rule is, and then let's talk about how this might apply to finishers.
The Toxic Substance Control Act under Section 8E, 8F allows EPA to obtain information from companies throughout the United States that may have chemicals of concern on their facilities or at their facilities. And they can do that not just for current, but historically. And so this rule came about after about a year and a half of gradual interest from EPA over PFAS or polyfluoroalkyl substances being present at industry throughout the United States. And they elected earlier this year, October 11, to publish a final rule stating that companies that have manufactured or imported any PFAS chemicals or any substances containing a PFAS chemical over the last 12 years to file a report electronically with EPA. It's not limited by industrial category, Tim. It's not restricted by type of business. It could apply to distributors. It could apply to manufacturers. It certainly could apply to the surface finishing industry, who have used a lot of surface coatings and other materials that or finishes that may contain these PFAS compounds in them.
Yeah. So, what I understand is that this update to this rule really took out any loopholes, right? It really required everyone. Is that fair to say?
Yeah, that's right. This rule is a reporting rule and a record keeping rule that has been expanded well beyond industry like surface finishers. You know, there is a companion information request under the Clean Water Act to learn what surface finishers are doing or have done with respect to polyfluoroalkyl substances within their industry over the last few years, primarily the last 3 years. This is a much broader application. It says if you manufacture or import any chemicals, and that includes, by the way, any products or articles or metal or other hard chemicals or hard products that have coatings on them that might contain a PFAS, you have an obligation to report. And that goes back to the presence on your products or in your formulations or in your hard materials, your articles, if you will, imported or manufactured since 2011.
2011, correct.
Right.
So the question a lot of finishers, and they're tossing this up now amongst themselves and asking, there's a suspicion, as we spoke about a while back, there's suspicion that they're getting parts from their customers that somehow have been treated with some type of PFAS, whether ingredient, whether it's a lubricant in oil, a corrosion resistant, something like that. Do you think that that would fall under this rule for them? If they get a part and they're working with it and coding it, would it fall under that, do you believe?
It would fall under this reporting record if the part was imported or otherwise produced at that facility, which is the trigger here. You might say, well, we're not an importer, we use a broker. Well, of course, EPA does not define the term importer narrowly. It defines it broadly. So there's a trigger of one of 8 or so factors that could place you as an importer if your product comes through a broker, such as a hard finished product with greases or lubricants, and those lubricants came from a foreign entity and were imported into the United States. If you're the primary entity taking that product and you're the only one for which it was brought to the United States, even if you use a broker, you can still be the importer. If you take title to it at the port without going through the broker's title, you can be held responsible as an importer. So it's not just well, we ordered it from overseas. It's more than that. And I would encourage industry to look at whether they have any products coming from afar that might be into this category. And that includes hard products like we talked about with greases and lubricants, but also the greases and lubricants themselves, or the finishes themselves, or the heavy metals, wherever they're getting their acids from, their sulfurics, their cyanides, wherever those materials are coming from. If they're coming from imports, and a lot of them are, then they may fall into the importer category.
Gotcha. So just to clarify though, if this is a shop, say in Detroit, and they're getting parts from a shop in Ohio or a manufacturer in Ohio, they're coming in. Does this apply to them, or is it just parts that are coming outside the country imported in?
This particular rule would only apply if they were importing the product from outside the United States.
Gotcha.
That's not the case with the other rule we talked about previously, which was the information request rule under the Clean Water Act. Those would still be applicable, and they would still be triggered for that facility that purchased from an Ohio supplier.
Gotcha. Gotcha. So finally, let's just ask this question. Shops, what questions should they be asking themselves? Are there two or three questions that they need to ask themselves to determine whether they are susceptible to this rule and must report?
Yeah, I think first and foremost, do they have any relationship with imported chemicals, imported products of any kind? Secondly, when the rule was proposed a few years ago, it was a fairly limited list of polyfluoroalkyl substances. This reporting rule is much broader, and EPA estimates it'll cover 1,300 plus chemicals. And that means we're talking about if we import a fairly significant likelihood the PFAS is on the list if there's any fluorinated compounds as part of that process. I would also tell them that they have a little bit of an extra burden here. We have a tendency to say, let's not ask questions because we may not want to know the answer. And I subscribe to that philosophy. But this rulemaking places an express burden on the company to make meet a standard called reasonably ascertain. That means going back 11 or 12 years, 13 years, to determine if, through reasonable investigation, if we had any imports. If we had imports, did they contain any of these 1,300 plus chemicals? Were we an importer and we didn't know it? In other words, did we fill that role? Are any of the products that we have currently on the site? A common one, Tim, has been AFFF. A lot of facilities with firefighting systems have firefighting foams. Those, until about 2015, were almost universally supported by PFAS compounds. And if they remain in inventory today, which a lot of them do, there's no shelf life to speak of for an AFFF foam. If you have firefighting foam at your facility, you likely have a compound that falls into this category, and many of the suppliers were importers in the early days. So that's another category. To understand what reasonably ascertained means, EPA says not just what you know from your SDSs, you're charged with looking at what the industry partners are doing. And are they reporting? And that's key because once this information goes into the data bank at EPA, they're going to form a sector analysis. And if our sector has a lot of imported PFAS chemicals, somebody's going to ask why our facility is not there. So when you ask what should they be doing, I think they have to take the reasonable ascertain standard pretty seriously and do their homework.
Right. That seems like a pretty broad statement. Did you reasonably ascertain? Did you try to find out? Is really what they're
That's right.
trying to put with that.
That's
Great.
right.
Well, listen, I'll put your web address right there below. If any shops do not have somebody that can advise them on these environmental issues, I would advise them to encourage them to reach out and talk to you. But again, thanks for the insight. We very much appreciate it.
You're welcome, Tim. Good to see you.